Good morning. I'm State Senator Phil Boyle, represent the 4th Senate District, and joined here with some of my colleagues from the State Senate and Assemblyman Doug Smith, and a special guest, Suffolk County District Attorney Ray Tierney, who drove all the way up from Long Island for this press conference. We're here today because of a very important issue that just came to light last week. I, as an individual, have been working on DNA-related legislation on a federal and state level literally since 1988, since it just started in this country. We've seen many advances over the years, obviously, and one of the newer advances is called familial DNA searches. I'll explain it as best I can. I'm not a scientist, but basically, there's a crime scene, a defendant left their DNA, whether it's blood, semen, and the law enforcement, as anybody has seen a true crime show, does the DNA match, looks into the database that the state holds for anybody convicted of a crime, and there's not a direct link. So without familial DNA, that's the end of the story. What some of the lab technicians will sometimes find, however, that there's a partial match, that it's close to someone that's in the system, say their father, their uncle, their brother who is in jail for something else. Obviously, that greatly reduces the number of suspects from millions to maybe half a dozen to find out who committed a crime. And we're only talking about violent crimes here: murder, rape, kidnapping, terrorism. So New York State in 2017 became one of 11 states that allow this familial DNA searching, so to a great law enforcement tool for our prosecutors and our police. It was, the way it came into being was not through legislation, but through a decision made by the New York State Commission on Forensic Sciences and their DNA subcommittee. They said we're allowed to use DNA familial searches in New York State, and these are the guidelines, to be very careful that no one's civil liberties are being abused, on which you will follow do this familial search. I, at that time, in 2017, introduced legislation and passed it in the state Senate on a bipartisan basis to allow the familial searches in New York State. It never passed in the state assembly, but it passed overwhelmingly 49-11 in the state Senate. At that time, we thought it was a done deal. The commission had spoken, and familial searches would be allowed to be used by law enforcement officials in the state of New York. Fast forward to last week, when an appellate division case in New York City said that familial cases would not be allowed because the legislature never passed it into law, throwing it back into the hands of the state legislature. That is why I immediately introduced legislation with my sponsor in the Assembly, Assemblyman Doug Smith, to allow familial DNA searches. It's a vital tool, and I'm going to let District Attorney Tierney speak to a little bit about this, but I do want to point out that there's two ways that this can be fixed. One is New York State Attorney General Letitia James can appeal the case to the Court of Appeals. I pray that she does that and she wins, in which case familial DNA searches for law enforcement will be allowed again. But that could take a long time, and the Attorney General may decide not to do that. So the other option is to pass the legislation here again in the Senate and the Assembly. We have about 3 weeks left in the legislature. I cannot think of any more important issue that we should be working on to protect New Yorkers. I'm just going to remind everyone that this familial searches are only done for violent crimes: murder, rape, kidnapping, terrorism, and other violent crimes. No one's doing a familial DNA search for a jaywalker or a burglar or something like that. It's just really bad people that you want to get off the street. And I know the majorities in both of these houses talk a lot about protecting women. Well, the fact is the vast majority of the victims of these crimes are women. And I would point out also that in 2017, when my bill was passed, we had a lot of Democrat support, including Andrea Stewart-Cousins, who now serves as our majority leader of the state Senate. So I would respectfully ask that the majority leader bring this bill up for a vote. Doesn't even have to be my bill. Let a Democrat sponsor it. I'll be happy to co-sponsor, and I know Doug Smith feels the same way. No pride in authorship. Let's get it done. Let's pass legislation so the legislature is on record, making it legal to allow familial DNA. We already have the guidelines in place because the commission has already given the guidelines. They can just meet again and vote on them again. And with that, I'm very proud to introduce our new Suffolk County District Attorney. I am not going to read you his resume because we'll be here all day. County, state, federal prosecutor for decades, on the day he arrived in office in Suffolk County, he was the most experienced prosecutor in the state of New York. So Ray, thank you so very much for coming in, please.
Thank you. I want to thank Senator Boyle and his colleagues in the Senate and Assembly for asking me to come and speak here. I've come from Suffolk County because this is a very important issue. This is an important issue which directly involves public safety. When we talk about DNA, we're talking about family DNA. That is a DNA search through the Department of Criminal Justice Services, as well as genealogic DNA, which is the DNA profiles obtained from publicly available databases. And there are two bills that Senator Boyle has put forth, and I'm urging Senator Boyle's colleagues in the Senate and the Assembly to pass those bills, because these DNA databases, this technology, it's critical in helping us solve violent crimes, rapes, murders, cold case murders, and without this critical tool, there are going to be dangerous individuals who will avoid justice. Just this year, upon becoming DA, we solved a 42-year-old murder, the murder of Eve Wilkowitz. She was murdered on March 22nd, 1990 in Bayshore, New York. And for 42 years, that crime went unsolved. And we were able to use this genealogic and this familial DNA to finally find the perpetrator. And although that individual had already passed away, we were able to use this technology to bring a small measure of closure to the victims in this case. And it's critically important. If it wasn't, I wouldn't be here. So I'm urging the Assembly and the Senate to pass these two bills. And really what I would ask is, we're talking about a rising tide of crime, and the public is concerned, and our public officials, our assemblymen and our congressmen are talking about public safety. What I'm asking them is to stop paying lip service to public safety and actually do something. Give prosecutors the tools they need to address these very serious problems. Thank you.
Thank you very much, Ray. And that actually concludes the press conference. If you have any questions, first on topic would be best if, yes.
How does law enforcement obtain familial DNA? What are the types of sources? And what legal impediments?
Why don't you go in front of you? Go in front of you.
Sure. So with regard, it's a term of art. So familial DNA. So what normally happens is when you have a cold case and there's some DNA that's found at the scene of one of these violent crimes, it would be submitted through the CODIS system, which is the national system, or DCJS, which is the local system. And there's 3 different areas on the DNA which you're looking for, and if it's a match on all 13, then you have your suspect. But sometimes you'll get a match in only certain areas, which indicates that the perpetrator of the crime, while not the profile of the person you're looking at, it is a close relative. And so what DCJS will do, they'll provide law enforcement with that information, and we could do further investigation to find the actual perpetrator. And then when you talk about genealogic DNA, that's DNA that's available on public databases. And again, you could do the same thing. You could provide a comparison to find or submit a swab taken from the crime scene to either get the exact DNA profile or the profile of a close relative.
Is this about finding a tip to lead you to more evidence, or is this itself to have an exact conviction?
Well, if it's the actual individual, it'll take you to the perpetrator. But sometimes what it'll do, like in the Wilkowitz case, the genealogic DNA took us to a close relative of the perpetrator, and we did a genealogic search of that individual. We went back to the crime scene. We re-interviewed people. We looked to see what happened, and we developed a suspect. And then we exhumed, because that suspect, Herbert Rice, he died in 1991. So we exhumed the body. And we compared his DNA with the DNA found at the scene, and it was an exact match.
When you say the match or the family match, are these people compelled to cooperate with law enforcement?
Well, if it's DCJS, if they were convicted of a crime, their DNA profile is collected and placed in this database. And then with regard to the other, it's publicly available DNA.
Publicly available, you mean like the geological companies?
Yes.
So they give this up?
Well, we have to have a warrant. We have to have predication, and that's how we get it. We just don't, just get it. We have to have predication.
In states where this is already legal, have you ran into any problems? People, the court's saying that it could be in opposition to the Fourth Amendment.
Well, I don't really see how it would be in opposition of the Fourth Amendment because it's based on predication, so as long as you have predication and you've done the proper investigative steps, obviously if it doesn't comply with the Fourth Amendment, you would run into problems. But I don't see how it could as long as you follow the proper Fourth Amendment steps. And when you talk about publicly available stuff, we as government actors, we comply with the Fourth Amendment. Google, Apple. They're spying on us all the time. They don't comply, and no one seems to have a problem with that.
And I'm sorry, in the family, if you get a near match, how many we're talking about out of 13? How many? 10 or 11?
It takes expertise. So the DNA analyst will tell you that although this isn't a match, based upon the profile and the comparison with a particular individual, we can say that it is a close relative. And usually what we'll do is there's a STR analysis, which is short tandem release, and there'll be the Y STR analysis, the Y chromosome meaning the male. So when you get a comparison that's close, based on their protocols, they'll say it is a close male relative of this individual.
And would it be like would it have to be a sibling or a child?
It's a close male relative, so through further analysis you'd be able to determine whether it's a brother, a father, an uncle, a male relative. Again, it would depend upon the sample, and it's individualized, but it certainly could be.
It seems like a lot of people, the potential there. Are these people required then to cooperate?
No, what you would then what we did in the instance of the Eve Wilkowitz case, we took that information, we did a genealogic search, we basically tracked the family back to Bayshore, and we learned that the individual Herbert Rice was staying at a home that was within the route that the victim took on her walk home from the train station, and it was something that was initially missed. So once we established that predication, we then used that to exhume that individual's body, and we compared the DNA, and it was an exact match. And go ahead. In that case, there was a relative who did cooperate, yes.
And if they don't cooperate, can you?
You could still get, again, it's highly individualized. In this instance, there was a close male relative that did cooperate. That individual was closer in relation to the perpetrator. So once we got that DNA analysis, we were able to say, basically, that the relative committed this crime.
But if they don't, you can't subpoena them? Was this enough to subpoena someone?
Again, you could if you put your findings in a motion and it establishes a probable cause, then you could do it in a warrant. We didn't have to do that in the Wilkowitz case.
You mentioned the AG. Is that the only way to get that up to court of appeal?
Well, as would you want to answer?
She would be the one that would appeal it on behalf of New York State. I think it's her decision.
So the legislature can enact legislation, or the AG could appeal the decision, the lower court decision, to the Court of Appeals.
I would just point out, in furtherance of the district attorney's comments, so there is I think a preventative approach to having this available, because obviously a lot of criminals don't think they're going to get caught. They're never going to get my DNA. I wore gloves or whatever I had to do. However, maybe your dumb brother or father or uncle wasn't so careful, and you have to take that into account if you're going to commit a crime.
And the other thing that I would say is DNA inculpates means finds guilt, but it also exculpates, which means finds somebody who's not guilty of a crime. So if you have an individual who is charged with a crime and there's DNA at the scene, this could be used to eliminate suspects who, who didn't commit the crime. So it inculpates, it also exculpates.
1/3 of all tests exonerates a potential suspect. I also would point out, I talked to, since the court decision came down, I talked to people at the New York State Forensic Lab down the street and here in Albany, and they were called immediately when this decision came down to stop familial testing. They do it about one a month. Extrapolate that out to potentially, we could get some very violent people off the street, and we're not doing it as long as this is law right now. Anything else? Well, thank you very much. I really appreciate you coming. Thank you. Thanks. Great job.